assignment, and the rest is already in the documents. I'll read it and then you can read the approval. Okay, fourth supplemental pledge and assignment agreement. The fourth supplemental pledge and assignment agreement, parentheses, the assignment is made and given effective this blank day of blank 2013 by the Crow Tribe residents, parentheses, together with any successors hereinafter collectively referred to as the signer. And First Interstate Bank and Montana Banking Corporation, parentheses, together with any successors or permitted assigns hereunder referred to as the assignee, parentheses, witnesses. Whereas the assigner is authorized and empowered pursuant to resolutions JAR 13-blank to borrow money and issue obligations to finance the operating costs for land purchases, economic development projects, and other purposes, and to pledge a portion of the interest the assigner receives from the Crow Tribal Trust Fund, parentheses, as hereinafter defined to secure such loan, and whereas the Crow Finance Authority has previously issued its tribal purpose revenue bonds, Series 1997, parentheses, the Series 1997 bonds, parentheses, for the purpose of financing the cost of certain projects approved by the Crow Tribal Council pursuant to the terms of that certain trust indenture dated as of January 1st, 1998, parentheses, the indenture between a signer and U.S. Bank Trust National Association, formerly known as the Trust National Association, parentheses, has entered into that certain pledge and assignment agreement dated January 1st, 1998. The pledge agreement, parentheses, wherein a signer and the Crow Finance Authority pledge and assign to the bond trustee of all of its rights, a signer and the Crow of its rights, title and interest in and to the assigned interest income as defined in the pledge agreement, parentheses, and granted a first lien thereon to bond trustee to secure repayment of said Series 1997 bonds. And whereas a signer has previously issued its Series A note and Series B note, parentheses, taxable, each dated February 2nd, 2000, parentheses, the 2000 notes, to assignee as lender for the purpose of financing the cost of certain projects approval by the Crow Tribal Council pursuant to the terms of that certain loan agreement dated as of February 2nd, 2000, parentheses, the 2000 loan agreement between a signer and assignee, and has entered into that certain supplemental pledge and assignment agreement dated February 2nd, 2000. The supplemental pledge agreement, parentheses, wherein a signer pledge and assign to assignee all of its rights, title, interest in, and to the assigned interest income payment, and granted a first lien thereon to assignee to secure repayment of said 2000 notes, subordinate to the first lien of the bond trustee on such assigned interest income payments. And whereas a signer has previously issued its Series A note dated September 21st, 2007, parentheses, 2007 note, to assignee for the purpose financing the certain projects approved by the Crow Tribe legislative and executive branches pursuant to the terms of that certain loan agreement dated as of September 21st, 2007, the 2007 loan agreement, parentheses, between a signer and assignee, and has entered into that certain second supplemental pledge and assignment agreement dated September 21st, 2007, the second supplemental pledge agreement, parentheses, wherein a signer pledge and assign to assignee all of its rights, title, interest in, and to the assigned interest income payments, and granted a first lien thereon to assignee to secure prepayment of said 2007 note, subordinate to the first lien of the bond trustee on such assigned interest income payments, and the first lien of the assignee on such assigned interest income payments. And whereas the assigner has applied to the assignee for a simple advance term loan in the aggregate principal amount of $10 million, the 2013 loan, parentheses, which will be used to 1. Pay off and extension of credit previously extended by the assignee to the assigner in the original principal amount of $3 million to the borrower under loan number 19033244410 on April 9th, 2013. The April 2013 loan parentheses. Number 2, fund tribal economic development projects and land purchases. And number 3, other purposes. And whereas, with respect to the 2013 loan, the assigner and the assignee have entered into a loan agreement dated the date hereof, the 2013 loan agreement, parentheses, pursuant to which the assigner issued and delivered to the assignee that certain promissory note, dated the date hereof, the 2013 note, parentheses, in amount of and as evidence of the 2013 loan, and whereas pursuant to section 4.4 of the 2013 loan agreement, as security for repayment of the 2013 loan, the assigner has agreed to assign and pledge to assignee a portion of the assigned interest income payments. Now, therefore, in consideration of the 2013 loan by the assignee to the assigner, the execution and delivery of the note and the mutual covenants and conditions set forth herein, the assigner and the assignee hereby agree as follows. All the rest is defined, not defined, but it's inside in the other agreements, or you want me to continue reading? Did you guys kind of...
Mr. Chairman, I would say 90%, 95% of this is already these other agreements that
So just continue reading then, finish it. Okay.
I noticed a couple of paragraphs that aren't included. Most of it's still. It's just redundant.
Okay, it's just redundant then. So just continue reading. Your legal opinion.
Continue reading.
Okay. Number 1, define terms. Capitalized terms used in the assignment and not defined herein shall have the meanings ascribed thereto in the 2013 loan agreement unless the context clearly requires otherwise. Number 2, grant of assignment for valid receipt to secure the obligations of assigner to pay the assignee the amounts payable under the 2013 loan agreement and the 2013 note. Assigner hereby assigns and pledges to assignee all of the following hereinafter the assigned sums, parentheses. A. Assign interest income payments. All right title interest of the assigner to the following portions of the payments due from the Office of Management and Budget and or the Department of Interior, Office of the Special Trust for American Indians, parentheses, OST, to assigner the assigned interest income payments, parentheses, under that certain undertaking of the United States of America to deposit royalties received from several coal mines operating in the state of Montana up to the sum of $85 million, excluding interest and escrow funds, into the Pro-Tribal Trust Fund, the interest on which is to be made available to assigner as set forth in the Crow Boundary Settlement Act of 1994, 25 U.S.C. 1776D, parentheses, the Act, which authorized distributions from the Pro-Tribal Trust Fund for education, land acquisitions, economic development, youth and elderly programs, or other tribal purposes. The assigned sum shall consist of that portion of the assigned interest income payments due under the terms of the Act, which is equal to the sum of the loan repayments and other sums due and payable under the 2013 loan agreement and 2013 note, parentheses, the obligations. It is expressly recognized the assignee security interest in the assigned interest income payments are and shall be subordinate to 1A. 1. Bond trustees first lien for so long as assigner has outstanding debt service requirements on the series 1997 bonds according to the terms of the indenture and pledge agreement. Number 2, assignees subordinate lien for so long as assigner has outstanding debt service requirements on the 2000 notes according to the terms of 2000 loan agreement and the supplemental pledge agreement. And number 3, assignees subordinate lien for so long as assigner has outstanding debt service requirements on the 2007 note according to the terms of the 2007 loan agreement and the second supplemental pledge agreement at such time as assigner's debt service requirements on the series of 1997 bonds, the 2000 notes, and the 2007 note have been satisfied and discharged. The assignee shall thereafter have a first lien on the assigned interest incomes. B. Ancillary rights and proceeds. All and any other rights and property interests arising out of or relating to the assigned sums, all other and additional securities or property, including cash, parentheses, which may be made or distributed in respect to the assigned sums. C, proceeds, all proceeds, both cash and non-cash, parentheses, of the foregoing, whether now or hereafter arising under the foregoing. D, governmental notice. By copy of this assignment delivered to the Office of Management and Budget and or the Office of Special Trust for American Indians of the United States Department of the Interior, the assigner hereby directs the OST to pay the assigned sums when due directly to the assignee for an immediate application and payment of the obligations then or next due. Assigner agrees to execute such further notices, demands, or other documents necessary to cause the Office of Management and Budget and or the Office of the Special Trust for American Indians of the United States Department of the Interior to pay the assigned sums directly to the assignee. 3. Obligations assured. This assignment is granted to the assignee for the purpose of securing payment of the following obligations of the assignor. A. Payment of the principal sum of $10 million or so much thereof as has been advanced under the terms of 2013 note, together with interest thereon according to the terms of the 2013 note, and any extensions, renewals, and or modifications thereof. B. Payment of all other sums becoming due or payable under the provisions hereof or under the 2013 loan agreement, together with interest thereon at the rate specified in the 2013 loan agreement or the 2013 note, as case may be. C. Payment of all other sums which may be advanced by assignee in its discretion for the protection of its interest in the assigned sums, including but not limited to payments made on indebtedness of assigners constituting the prior lien on the assigned sums, together with interest thereon at the same rate specified in the 2013 note from and after the date of any such advance. And D. Performance of each and every agreement and covenant of assigner contained herein in a 2013 loan agreement and in a 2013 note secured hereby. 4. Representations and warranties of assigner warrants and covenants as follows. A. Perfection of interest in assigned sums. Assigner agrees to execute and deliver such financing statements, continuation statements, or other documents that may be necessary to take whatever other action may be requested by assignee to perfect and continue assignee's interest in the assigned sums. Assigner hereby irrevocably authorizes assignee to cause financing statements and amendments thereto and continuations thereof, parentheses, and other documents that may be necessary to be recorded and filed at such times and places and as may be required or permitted to create, perfect, and preserve the security interest in the assigned sums, and to the extent necessary to exercise the foregoing authorization, hereby irrevocably appoints assignee the assigner's attorney in fact for the purpose of executing any documents necessary to perfect or to continue the interest granted herein. Assignee may at any time and without further authorization from assigner file copies of the assignments as a financing statement. B. Transactions involving assigned sums. Assigner agrees, notwithstanding the provisions of section 2.10 of the indenture, that it will not, without the prior written consent of the assignee, grant a lien or other security interest in the assigned sums on a parity with the series of 1997 bonds, the 2000 notes, the 2007 note, or the 2013 note without the express written consent of the assignee. Assigner may, without the consent of the assignee, grant a lien or other security interest in the assigned sums if such lien or security interest is expressly junior and subordinate to assignee's security interest in the assigned sums. C. Taxes and assessments. To the extent lawfully and applicable, assigner shall pay all taxes, assessments, or other impositions relating to the assigned sums before the date that the same become delinquent, provided, however, assigner shall not be in default hereunder by reason of the failure to pay such taxes, assessments, or other impositions, so long as the assigner shall contest in good faith the existence, amount, or validity thereof, or the extent of its liability therefore, by appropriate proceedings, including appeals, parentheses, which shall operate during the pendency thereof to prevent, number 1, the collection of or other realization upon such tax, assessment, or other imposition so contested, or number 2, the sale, forfeiture, or loss of the assigned sums. D. compliance with governmental requirements. A signer shall comply promptly with all laws, ordinances, and regulations of all governmental authorities lawfully applicable to the ownership or use of the assigned sums, provided, however, a signer may withhold compliance with any such law, ordinance, or regulation so long as the assigner shall contest in good faith the existence or validity thereof, or the extent of its liability or responsibility therefore, by appropriate proceedings, including appeals, parentheses, which shall operate during the pendency thereof to prevent the sale, forfeiture, or loss of the assigned sums. E. Prior assignment of assigned interest income payments. Assigner warrants that it has previously secured the series 1997 bonds, the 2000 notes, the 2007 note by the pledge agreement, the supplemental pledge agreement, and the second supplemental pledge agreement, respectively, each of which pledge and assign all of the right, title, and interest of the assigner to the assigned interest income payments, and granted a first lien thereon to bond trustee to secure repayment of the series 1997 bonds, and a granted subordinate lien thereon to the assignee to secure repayment of the 2000 notes, and granted a subordinate lien thereon to the assignee to secure repayment of the 2007 note. A signer further warrants that it has not granted, bargained, sold, assigned, pledged, transferred, conveyed, warranted, mortgaged, hypothecated, or otherwise encumbered the assigned interest income payments to secure any other indebtedness. Number 5, care of assigned sums. The assignee shall use reasonable care in the physical preservation and custody of the assigned sums in its possession and their immediate application and payment of the obligations, but shall have no other obligation to protect the assigned sums or its value. In particular, but without limiting the foregoing, assignee shall have no responsibility for the collection or protection of any income on the assigned sums, preservation of rights against parties thereto or against third persons, ascertaining any maturities, calls, conversions, exchanges, offers, tenders, or similar matters relating to any of the assigned sums, nor for informing the assigner about any of the above, whether or not assignee has or is deemed to have knowledge thereof, provided assignee shall perform assigner of assignee's receipt of assigned sums and immediate application thereof in payment of the obligations. Assigner hereby waives presentment, protest, demand, or notice of dishonor or non-payment to the assigner or to any maker, endorser, surety, guarantor, or other persons who is a party of the assigned interest income payments and agrees that the assignee shall have no obligations to commence litigation, notify assigner or anyone else, or take any other action to prevent the running of any statute of limitations. 6. Necessary endorsements or documents. Assigner agrees to execute and deliver to the assignee on demand any statement, endorsement, note, or bond, power, parentheses, instruction, or other document which the assignee in its sole discretion requests as being necessary to create, preserve, validate, or enforce its interest in the assigned sums. 7. Events of default. The occurrence of any one or more of the following events shall constitute a default hereunder. The events of default, parentheses. A. If a signer shall fail to make any payment when due hereunder or under the 2013 loan agreement or the 2013 note, and the time for cure of such default pursuant thereto shall have expired, and such default shall not have been waived by assignee. Or B. If a signer shall fail to observe and perform any other covenant, condition, or agreement on his part hereunder, and such default continues for 30 days, parentheses, after written notice specifying such default and requesting that it be remedied, it is given to the assigner by the assignee, provided that if any such term, covenant, or agreement in such that non-performance or non-observance thereof cannot be corrected within such 30-day period, or if force majeure prevents correction within such period, the non-performance or non-observance shall not constitute an event of default hereunder if corrective action is instituted by borrower within such period, or in the event of a force majeure in whatever period corrective action is practicable, parentheses, and diligently pursued correction. Or C. If a signer shall 1. Admit in writing its inability to pay its debts generally as they become due, or 2. Admit in writing the fact that its debts exceed a fair valuation of its property Or 3, commence a voluntary proceeding under any applicable federal or state bankruptcy, insolvency, or other similar law. Or 4, make an assignment for the benefit of its creditors. Or 5, consent to the entry of an order for relief in an involuntary proceeding under any applicable federal or state bankruptcy, insolvency, or other similar law. Or 6, have entered against it by a court of competent jurisdiction a decree or order granting relief in any involuntary case under any applicable federal or state bankruptcy law, or appointing with or without the consent of the assigner a receiver, liquidator, assignee, custodian, trustee, sequestrator, or similar official of the assigner, or for any substantial part of its property, or approving a plan for reorganization of the assigner, or ordering the winding up or liquidation of its affairs, and such decree or order shall not be vacated, set aside, or stayed for a period of 60 consecutive days. Or D, if any representation or warranty made by the assigner in this assignment or in the 2013 loan agreement shall prove to have been incorrect in any material respect was made. Or E, the occurrence and continuance of any event of default is defined in the 2013 note or the 2013 loan agreement. 8, rights of assignee upon an event of default. Upon the occurrence of an event of default, assignee may exercise any one or more of the following rights and remedies in addition to any other rights or remedies that may be available under the 2013 loan agreement or the 2013 note at law, in equity, or otherwise. A, proceed to protect and enforce its rights by a suit or proceeding consistent with paragraph 15 below, either for the specific performance of any covenant or agreement contained herein or in the 2013 loan agreement, or in aid of the execution of any power herein or therein granted, or for the enforcement of any other appropriate legal or equitable remedies. Or B, subject to paragraph 15 below, the assignee shall have and may exercise any or all relevant rights and remedies of the secured creditor under the provisions of the Montana Uniform Commercial Code and the Absolvable Secured Transactions Act at law, in equity, or otherwise. 9, waiver. Neither assignee nor assignor shall be deemed to have waived any rights hereunder or under the loan agreement (parentheses) unless such waiver is in writing and signed by such party. No delay or omission on the part of the assignee or assigner in exercising any right shall operate as a waiver of such right or any other right. A waiver by any party of a breach of provision of this assignment shall not constitute a waiver of or prejudice the party's right otherwise to demand strict compliance with that provisions or any other provision. Whenever consent by assignee or assigner is required herein, the granting of such consent in any instance shall not constitute continuing consent to subsequent instances where such consent is required herein. 10, remedies cumulative. All of the assignee's rights and remedies, whether evidenced hereby or by any other writing, shall be cumulative and may be exercised singularly or concurrently. Election by assignee to pursue any remedy shall not exclude pursuit of any other remedy, and an election to make expenditures or take action to perform an obligation of assigner under this assignment after assigner's failure to perform shall not affect assignee's right to declare a default and exercise its remedies hereunder. 11, successor interest. This assignment shall be binding upon and inure to the benefit of the parties, their successors, and assigns. 12, notices. All notices which are required to be given or may be given to the parties pursuant to the terms of this assignment shall be sufficient in all respects if given in writing and delivered personally or by registered or certified mail, postage prepaid, as follows. Assigner, Crow Tribe of Indians, P.O. Box 129, Crow Agency, Montana 59022. Attention Chairman, Executive Branch. Assignee, First Interstate Bank, 402 North Center Avenue, P.O. Box 903, Hardin, Montana 59034. Attention Commercial Loan Department. Each party may change the address at which it is to receive communication by written notice to the other party. 13, expenses, costs, and attorney's fees. If an event of default, as defined in paragraph 7 above, parentheses, occurs, an assignee is required to commence any suit or action or proceeding to enforce any of the terms of this assignment, a proceeding in parentheses, then the prevailing party shall be entitled to recover from the other party reasonable attorney's fees and legal expenses incurred in said proceeding, whether prior to or during such proceedings, and all such fees and expenses with respect to a judicial proceeding as defined in Exhibit A hereto, parentheses, in addition to all other sums provided by law. In the event that assignee is otherwise properly required to incur any reasonable expenses whatsoever to protect or enforce its rights hereunder, whether or not a proceeding is commenced, assignee shall be entitled to recover any and all such sums and all incidental expenses, including such reasonable attorney's fees. All such sums shall be part of the indebtedness to be paid from the assigned sums. 14. Savings clause, severability of provisions controlling law. All warranties, representations, and covenants set forth herein shall survive the execution of this assignment. If any portion of this assignment shall be held to be void or unenforceable, the balance thereof shall nonetheless be effective. By agreement of the parties, this assignment shall be governed by and construed and enforced in accordance with the laws of the state of Montana, including any relevant provisions of the Montana Uniform Commercial Code, provided that this is not intended and shall not be interpreted as a concession by the signer to the state of Montana has lawful authority to regulate the activities of a signer or its officers, employees, or agents. In addition, this assignment shall be governed by and construed in accordance with any applicable and controlling federal law. 15. Limited waiver of immunity. In the event any action or proceeding is commenced by the assignee or the assigner with respect to enforcement of the 2013 loan agreement, the 2013 note, or this assignment, such action or proceeding shall be settled by binding arbitration administered by the American Arbitration Association, parentheses, AAA, under its commercial arbitration rules, and judgment upon the award rendered by the arbitrators may be entered in a courts with jurisdiction of the matter as set forth in Exhibit A hereto. Subject to the limitations set forth on Exhibit A hereto, the assigner hereby specifically waives any claim or right of the assigner as an entity to sovereign immunity with respect to any such action or proceeding, and consents to this jurisdiction of the courts as provided in Exhibit A solely for the enforcement of this assignment. The foregoing jurisdictional waiver and consent provisions and the choice of law provisions of paragraph 14 above are for the benefit of the assignee or other owner or holder of the 2013 note, parentheses, exclusively, and are not intended and shall not be construed to benefit or otherwise bestow rights on any other parties or any party other than an assignee or other owner or holder of the 2013 note. In witness whereof, the assigner and assignee have each caused this assignment to be executed by its duly authorized officer of the date first above written. Pro-tribe business federally recognized and identified by Darren O'Connell, Chairman, Executive Branch, President, State Bank, Montana Banking Corporation. The assignee. This one. So there's just so don't need to read it. It's already in it. Okay. Okay. So at this time, need a motion to adopt the fourth supplemental pledge and assignment agreement. Motion is made by Senator Stewart. Need a second. Second by Senator Montrey. Question? Question by Senator Coyote Runs. Okay, all those in favor of the motion to adopt the fourth supplemental pledge and assignment agreement, raise your right hand. 9, unanimous. Chandler's is 9.5. Okay, who wants to read the last one? Bill.
These are part of the JDR.
Okay, the approval, gotta get read with the vote. Oh, yeah.
Okay, reading of the approval by Marlon passes. Approval pursuant to and as required by 25 USC section 1776D, parentheses D, parentheses 1 and 1776D, parentheses E, the Bureau of Indian Affairs, a part of the United States Department of the Interior, parentheses BIA, acting under delegated authority, hereby acknowledges and grants its approval of the pledge and assignment by the tribe to First Interstate Bank as lender, parentheses the assignee of the assigned sums consisting of that portion of the interest income on a co-tribal trust fund established in the Treasury of the United States of America pursuant to 25 USC section 1776D, parentheses the interest income, which is available after payments of amounts due and payable, parentheses I, to U.S. Bank Trust National Association, formerly known as First Trust National Association, parentheses, as bond trustee, parentheses, the bond trustee, pursuant to the pledge and assignment agreement dated as of January 1st, 1998, between the tribe and Crow Finance Authority, parentheses, the authority, and the bond trustee of the portion of the interest income necessary to pay the principal of and interest on the obligations of the authority issued pursuant to the trust indenture dated as of January 1st, 1998, between the authority and bond trustee, parentheses 2, to assignee as lender pursuant to a supplemental pledge and assignment agreement dated as of February 2nd, 2000, between the tribe and assignee of the portion of the interest income necessary to pay the principal of and interest on the obligations of the tribe under its 2000 notes dated February 2nd, 2000, in parentheses 3, to assignee as lender pursuant to the second supplement pledge and assignment agreement dated as of September 21st, 2007. Between the tribe and the 2007 lender of the portion of the interest income necessary to pay the principal of and interest of the obligations of the tribe under a Series A note dated September 21st, 2007. The assigned sums are assigned by the tribe to the assignee pursuant to the terms and conditions of the fourth supplemental pledge and assignment agreement dated as of blank 2013, dated this blank day of blank 2013, United States Department of the Interior, Bureau of Indian Affairs, by blank is blank. Accommodation, approval, and disclaimer. The Crow Tribe of Indians. The tribe, a federally, parentheses, the tribe, a federally recognized Indian tribe, has submitted documents identified as 2013 single advance loans secured by interest from the 107 Settlement Trust Fund to the Department of the Interior, and has requested that the Department review and approve the documents in accordance with 25 U.S.C. Section 81. In an effort to comply with the tribe's request, the Department has reviewed the identified documents and determined that do not represent agreements which require the payment of money or other things of value in consideration of services for the tribe relative to Indian trust lands or other trust assets. The Department therefore concludes that 25 U.S.C. Section 81 does not apply to identified documents. It follows that the identified documents need no approval from the Secretary of the Interior or the Assistant Secretary of Indian Affairs. Notwithstanding the inapplicability of 25 U.S.C. Section 81, the tribe has requested that the identified documents be approved by the Department to strengthen the tribe's legitimate authority to negotiate and sign the documents. As an accommodation to the tribe, the Regional Director of the Rocky Mountain Region, the Bureau of Indian Affairs, on behalf of the Secretary of the Interior and the Assistant Secretary, Indian Affairs, hereby approves the documents identified as 2013 single advance loans secured by interest from the 107 Settlement Trust Fund. This approval provided by the Regional Director on behalf of the Secretary of the Interior and Assistant Secretary, Bureau of Indian Affairs, is not intended to mean and should not be construed or interpreted to mean that the identified documents must be approved by the Department. In addition, this approval is not intended to mean and should not be construed or interpreted to mean that the United States assumes or guarantees any of the obligations imposed upon the tribe by the identified documents. Blank, Regional Director, Rocky Mountain Region, Bureau of Indian Affairs, on behalf of the Secretary of Interior and Assistant Secretary of Indian Affairs, State, blank. OST acknowledgement of loan for tribal government operations. The Office of the Special Trustee for American Indians of the United States Department of the Interior, OST parentheses, has been advised of and presented with the documents relating to a loan for tribal government and land purchases and economic development projects, parentheses, the 2013 loan between the Crow Tribe Indians, parentheses, the tribe and First Interstate Bank, a state banking corporation, secured party, parentheses, the terms of which require the tribe to grant the secured party a security interest in a portion of the interest income, parentheses, the assigned interest income on the Crow Tribal Trust Fund established in the Treasury of the United States of America pursuant to 25 U.S.C. Section 1776D, parentheses, the trust fund pursuant to the terms and conditions of the fourth supplemental pledge and assignment agreement dated as of blank 2013. Parentheses, the pledge agreement given by the tribe to the secured party to be executed within 5 business days of this acknowledgement. The pledge agreement secures repayment of the obligation of the tribe under the promissory note dated blank 2013 in the principal amount of $10 million, parentheses, the note. All capitalized terms used in this acknowledgement, but not defined, shall have meanings given to such terms in loan agreement dated as of blank 2013, parentheses, the loan agreement between the tribe and the secured party. OST maintains custody of the trust fund assets pursuant to the authority of 25 U.S.C. Section 1776D and American Indian Trust Fund Management Reform Act of 1994 conducts the administration and investment of such assets and responsibility for distribution of the tribe's trust fund earnings under Public Law 105-032, parentheses, Trust Fund Acts. The aforementioned functions and responsibility of OST were previously performed by the Office of Trust Fund Management, parentheses, OTFM. OST assumed such function and responsibility of OTFM relating to the tribe trust fund assets pursuant to a restructuring of the Department of the Interior. OST hereby acknowledges so as long as many of the obligations of the tribe under the terms of the note, the pledge agreement of the loan agreement remaining outstanding to comply with the following provisions. 1. In accordance with Section 5.1 of the loan agreement, OST shall cause to be transferred directly to the secured party the aggregate sum of $10 million in semi-annual installments of principal and interest due on January 25th, July 25th of each year, beginning on January 25th, 2014, by wire transfer in immediately available funds on or about 11 a.m. Mountain Standard Time, as set forth in SF-10-1034 dated blank 2013, received from the tribe all trust fund amounts constituting assigned interest income payments in amount shown on the foregoing SF-1034 received from the tribe, together with any other amounts due under the loan agreement as set forth in subsequent SF-1034 received from the tribe. OST represents that to the best of its knowledge, other than that set forth in the 4.5 of the loan agreement, it has not acknowledged, consented to, approved, or authorized any other loan or financing arrangement within the tribe has granted to any other party any right, title, or security interest in the trust fund amounts constituting the assigned interest income payments. OST acknowledges that although the trust fund amounts are considered a secondary source of repayment of the note, the loan agreement directs payments to begin immediately and to continue until all principal, interest, and other sums have been paid in full. Upon payment in full of 2013 loan and note, funds held in an account established by the secured party will not be accepted for deposit into the trust fund system within OST. By executed this acknowledgement, neither OST nor the United States of America assumes or guarantees any of the tribe's obligations under the 2013 loan. Further, this acknowledgement shall be effective upon execution of the note, the pledge agreement, and the loan agreement dated this blank day of October 2013. Office of the Special Trustee, Field Operations, by blank, name blank, title blank. October blank 2013, First Interstate Bank, Hardin, Montana, Crow Tribe of Indians, Crow Agency, Montana, R.E., Crow Tribe of Indians, $10,000 promissory note. Ladies and gentlemen, we have acted as counsel to the Crow Tribe of Indians, parentheses, the tribe in connection with the execution and delivery of the promissory note, parentheses, the note dated, the date thereof, hereof, reference above. In that connection, we have reviewed the following. 1. The Constitution and bylaws of the tribe. 2. Resolution JAR 13-blank of the tribe adopted blank 2013. 3. The loan agreement dated as of blank 213. The loan agreement parenthesis by and between the tribe and First Interstate Bank as lender, the lender parenthesis. 4. The fourth supplemental pledge and assignment agreement dated as of blank 2013 parenthesis. The fourth supplemental pledge agreement by and between the tribe and the lender N. 5. The note. 6. such other documents and certified certificates deemed necessary to render this opinion. Based on the foregoing, we are of the opinion that 1. The tribe is a federally recognized Indian tribe with full power to enter into loan agreement and first supplemental pledge agreement and to issue the note. The tribe has duly authorized, executed, and delivered the note, the loan agreement, and a first supplemental pledge agreement in each of the note, the loan agreement, and a first supplemental pledge agreement is a valid and binding obligation of the tribe, enforceable against the tribe in accordance with its respective terms, except for the extent enforcement thereof may be limited by bankruptcy, insolvency, or other laws affecting creditors' rights generally, and no further action is required to make it effective. 2. The execution, delivery, and performance by the tribe of each of the note, the loan agreement, and the first supplement pledge agreement do not conflict with or result in a breach of any terms or provisions of or constitute a default under any agreement, indenture, mortgage, deed, trust, indebtedness, lease, judgment, decree, order, statute, rule, or regulation to which the tribe is a party or by which they or their properties are bound or subject. 3. No approval, authorization, consent, or other order of any public board or body is legally required for the transactions contemplated by the loan agreement and the first supplemental pledge agreement by such approval has been obtained. 4. There are no pending or, to my knowledge, certain tribal, state, or federal legal, regulatory, or governmental proceedings to which the tribe is a party, which question the validity of or any action taken or to be taken by the tribe pursuant to the loan agreement and the first supplemental pledge agreement. 5. The note, the loan agreement, and the first supplemental pledge agreement contain 1. A limited waiver of sovereign immunity from suit should an action be commenced on or regarding the subject matter of those documents in any contractually described arbitral forum. 2. A consent to submit to binding arbitration of disputes, and 3. A consent of the enforcement of arbitration award initially in a Crow tribal court and in certain circumstances in other courts of competent jurisdiction. Such provisions are valid and enforceable in all respects. Proudly Fleck, PLLP may rely upon this opinion in delivering to you any opinions regarding loan evidence by the note, the loan agreement, and the first supplemental pledge agreement. Very truly yours, William C. Watt, Tribal Attorney, Office of Legal Counsel, Crow Tribe Executive Branch.
Okay, thank you, Marlon. Okay, need a motion to adopt approval, the approval, accommodations approval, disclaimer, OST acknowledgement of loan for tribal governments and the operations and the Apsaaloge Nation Legal Department. Need a motion on the floor. Motion by Senator Krugadar. Need a second. There's second. Second by Senator Not Afraid Bighorn. Need a question? Question by Senator Alden. All those in favor, raise your right hand. 9, 0, and 0. Okay. Okay, let me write it down. Okay, now we come to a discussion. Is there any discussion on what we read into the record for the minutes of the Revenue Committee? Going once. Okay, going twice. Okay, going 3 times. Okay, now we come to the recommendation for the full legislature next week sometime. Is there any discussion on the recommendation? Okay, do you feel that this is ready to go for approval? Floor recognizes Senator or Secretary Oldcrow.
Just for clarification and for understanding,
just for clarification and understanding what we're about to venture in, I know there was a lot of numbers and language that was thrown out there. I'm not an accountant, but I cheated. I used Excel, and anyway, with the interest rate as such, and if it stays the way it is, the loan payments every 6 months would be 466,699 approximately, and the total value after payment after the 15 years, if the interest stay as such, the principal would be 71% and the interest would be 29%. That's, well, the principal would be paid in full, but if you look at the pie chart, 29% of it would be the interest. So in other words, all said and done, the tribe would be paying $4 million in interest. So that's how much interest, but it is a low interest rate, however, but considering the magnitude of the loan, that way we see the big picture of what's actually happening instead of just seeing numbers and percentages and that. Oh.
Okay, what the interest is at this for 15 years, 2028. To say to pay it in full 2028, and then out of this $10 million loan, when it's all said and done and paid in full, we will pay an interest of $4 million as well. Any discussion, questions on that? That's the figure that Secretary Wolcott came up with. Senate floor recognizes Senator Stewart. Our Mike Man's campaign days. This is not necessarily concerning the numbers and all that, but I just wanted to ask a question for our legal. In the judicial proceedings under Appendix C, it's under the loan agreement, 1.2 judicial proceedings. It does state all judicial proceedings conducted pursuant to this Appendix C shall be initially commenced in Crow Tribal Court. Any judicial proceedings conducted in tribal court shall be conducted in accordance with the substantive law of the Federal Arbitration Act and the procedural law of the Crow Tribal Court, to the extent that such procedural law is not inconsistent with the Federal Arbitration Act and the procedures expressly provided herein. Then it goes on to talk about if we, there's a time frame and, if we don't meet that, then automatically goes here and there, and then if we don't want it in tribal court, then it goes here and like so, but I guess my question is, Chairman, is that, and this is probably for the legal, that do we even have the capability for the Federal Arbitration Act and procedural law in our Crow Tribal Court? And if not, do we need to adopt the law for arbitration in our Crow Tribal Law and Order Code to meet these accommodations so we don't have to punt it? That's my question. Okay, who wants to answer that one? Okay, Bill, go ahead, or Jay.
Thank you, Mr. Chair. I'm just going to note that I don't believe there needs to be any amendments to the Crow Law and Order Code to meet the requirements of the Section 1.2 language that Senator Stewart points out. And this is just a choice of law provision in a contract. It provides that in the limited circumstance in which you're going to be in court, because we're talking binding arbitration, if you're ending up in court, it's to enforce an arbitration award, or you're compelling a party to attend arbitration proceedings. The substantive law is the Federal Arbitration Act, which I'm not intimately familiar with. Bill probably is much more, So the procedural law I'm very familiar with because that is going to be principally Title V of the Crow Law and Order Code, our rules of civil procedure, and that's going to be how the process works. Now the law that would be applied is the Federal Arbitration Act, and I believe there is some. The Federal Arbitration Act, of course, is an act of Congress. We are referring to that law as what would substantively govern the parties in the context of the binding arbitration, whether there's already been an arbitration award made or whether we're trying to bring the parties to the table in Billings to actually have our arbitration proceedings carried out. So I think ideally, though, I was close with this, ideally we would want to have more of this type of law in our code, but it wouldn't be a requirement to effectuate this contract.
Go ahead, Bill.
Thank you, Mr. Chairman. I would agree with Jay. The Federal Arbitration Act does, I believe, preempt any other state or tribal law with respect to arbitration, being on the blunt end of that when the U.S. Supreme Court overturned the Montana Supreme Court in the Caserado case that our firm handled several years ago. I think the Crow tribal procedural law is sufficient to bring whatever action is necessary here. Ideally, it would be good to have an arbitration law, a general arbitration law for the tribe. To the extent it conflicts with the Federal Arbitration Act, it will create complexities on deals like this, and we need to be careful about that. And I think that's what I would say about that, but it's a good question. But the bottom line is I don't think the tribal court that we need additional code in order to enforce this provision.
Okay, is that suffice your question? So and so.
Yes or no, it says basically.
Mm-hmm.
Basically, the answer is yes, it'll stay in tribal court, and then yes, we're going to need arbitration law, but no, we don't think it's going to hurt us.
Mm-hmm.
That's the question, the answer I got.
Yeah. In other words, we need an arbitration law.
Yeah.
Okay. Yeah. Well. Okay, the interest rate is 4.79? 7.5. Yep. Is there any discussion on that? Any questions on the 4.75?
Well, I'll say it for them. We just need to make clear that everybody's understanding that this is a variable rate that is prime plus 1.5%. And the prime rate is adjusted by the governing board of the Federal Reserve Bank, so that is something that they control, and kind of like the price of money, I guess. Who makes just the prime rate? What does the Federal Reserve control? Well, Bill's going to teach us something on prime rate. I was wrong.
They control a discount rate, I think is what you're thinking of precisely. The prime rate is the overnight interest rate that large banks charge each other for deposits, and it's published in the Western edition of the Wall Street Journal as defined in herein. But it's one besides the LIBOR, the London Bank rate. It's the benchmark for loans, and in the United States it's probably the prevailing benchmark. But as Jay was getting ready to say, it is variable, adjusted annually. The prime in terrible times can, for short periods, jump up a bunch. So we don't know the ultimate costs of this loan. Right now the prime is about as low as it's been and it's been stuck here at 3.25% for quite a while. We are at only 1.5% or 1.5% above prime, which is a pretty good rate. But there is risk of it, of the prime rate increasing in the future since it is a short-term rate. And the cost of the loan being more than what they would be if you calculate it now. think Secretary Okro indicated that too in his calculations.
Thank you, Mr. Chairman. Members of the body, is there any particular reason why we elected to go with why we just didn't go with a fixed rate? I mean, being that you look back in the history, you said it has been stuck at, you know, what it is for a long time. Is there any particular reason why we didn't want to just, you know, ask for a fixed rate?
Thank you, Mr. Vice Chairman. I've not been involved in the substantive negotiations on the terms of the loan, so I don't know what considerations have gone into that exactly. You know, the bank will offer a much or a substantially lower rate at the beginning if it is adjustable, and they're not totally at risk in the long run. If I could inquire on a fixed rate loan. I think it's a little unusual in a commercial loan for 15 years, unlike a mortgage, but that's a possibility. You know, at the risk of the other possibilities are is to cap the amount it can increase in the year, to cap the total amount, all of which could be discussed if necessary.
Because, you know, in an amount this large, you know, $10 million, you know, if it does go up, you know, just half a point, 0.5%, that's $50,000. And that's just, you know, for 1 year, you're not compounding anything. But
Our fiscal year 14 budget does have, I believe, about 600, I'll use an approximate figure, about $650,000 authorized in the line item 2013 First Interstate Bank Note. So the tribe has already budgeted the payment, actually payments, it's obviously semi-annual, January and July. So that would of course be based on the entire principal being advanced to the tribe with the 4.75% interest rate. So that gives you an idea if the interest rate remains the same, what at least the initial payment, of course, that would decrease over time as the principal is knocked down. But just wanted to make a reminder on that.
Go ahead, give CJ the mic there. Bill. I just wanted to say, I have a question on the $3 million that we're going to be absorbing in this loan. What was the interest rate on that versus what we're paying now? Are we going to be, are we shaving, or are we going to be paying more points on money that, you know, maybe we're paying less on this $3 million now? And you know, I think that's a good question that Dana brings up, because I don't know if it's business savvy to absorb a loan if we're going to be paying a lot more interest on, you know, we're buying that money for more money, you know, against us. And I thought that loan was like two points, something like that, the first one. And so
I think it's probably +2.
but so it's like 2.5, 525. Okay.
This is a 0.5% lower, I'm pretty sure.
Okay. Well, I just wanted to bring that out, make sure that we're not absorbing some additional costs just to cover. And I think it would be nice to have a fixed rate. You know, although sometimes fixed rates aren't always the way to go, but you know, for a long term like this, I think we've earned our right to have the best deal possible with First Interstate Bank that's suitable for the Crow people and our people and our tribe and our business. and not theirs. So, I mean, if there's something better out there, then maybe we ought to shoot for that. Maybe there's something they can give us, or is this something that they threw at us that we just took? I don't know. I thought I'd ask because I think we've earned our right at the table to adjust for better rates.
I don't know, I think Dana, you can probably answer that, because the leadership, I don't think Bill can answer that, but I guess they can ask.
Yeah, I mean, I wasn't really, you know, a part of, you know, some of the talks and how it ended up, you know, being fixed versus variable rate. I don't know. I was, you know, you'd like to assume that, you know, you put people in these positions to negotiate these things to come up with the best bang for your buck. You know, I mean, I'm not a financial guy. You know, I mean, I have a hard enough time trying to manage my own finances. You know, but you know, I do agree that, you know, you should look at the best bang for your buck. You know, I mean, all the questions that you brought up, you know, some of the same questions that I have. And, you know, you look at this, I mean, I do, you know, I've always kind of ragged on First Interstate Bank, you know, and I've never appreciated the way that they treated our constituents. They go in, you go per capita, shucks, man, that line's long. And then when they get to the desk, they say, you know, we need 2 forms of ID. Why can't our tribal ID suffice, you know, for cashing your check? I don't know. They say it's bank policy, but everywhere else, you know, you go, especially if it's a check issued from that bank, you know, one form of ID should work. It seems like they made a policy to pick on us. I don't know, but I mean, that's beside the point. But this loan that we're getting, it's you know, just about as close to being like a secure loan as can be, you know, or the funds, the repayment, that, you know, it's there, it's guaranteed there, you know. So if you do go after, I mean, I've done it myself. I've had secure loans, you know, on cash, and shucks, those interest rates are, you know, about 2%, and I don't know. I mean, like I said, I wasn't a part of any of these negotiations. Maybe Bill was. Well, so I guess the people that, do you know who was part of it? So I guess the CPA, I mean, they should have been here. They should be here, I guess, to answer some of these questions. I mean, these are questions that we all have. I know that as a decision maker, you know, these are questions that you should have. You know, you got to have all your facts in front of you before you could make a sound decision for on behalf of your districts, you know, on behalf of the whole Crow people. So I think maybe we should you know, have him come over, Mr. Chairman, if you would, you know, allow that.
Okay, let's have a recess and ask her to come in. I think Senator Not Afraid Lashkraz has a question too.
Thank you, Mr. Chairman, members of the committee and executive branch, vice chairman, as well as representatives from the executive branch. First off, I am for progress. I am for the chairman of the executive branch has expressed interest in economic development. I am for that. I believe it is my duty to ask questions with reference to arbitration. Now, maybe this is a dumb question, and this question is for Mr. Watt. arbitration when it comes to a bank loan that is out there in the world of the state of Montana or the United States of America. Oftentimes I call it the real world, but I'm not trying to be condescending toward anyone, especially ourselves. The question is this how it's handled off the Crow Indian Reservation? Arbitration. If there's a dispute, there's a potential default on the loan, is arbitration how it's handled between a bank, the lender, and the lendee? Is this how it's handled? If Vice Chairman Wilson was to go into First Interstate Bank to get a personal loan, is that how it's handled through arbitration? Or Fortune 500 companies, or if the state of Montana were to acquire a loan, is this how it's handled through arbitration? I guess that's my question.
Thank you, Senator Nunn. I am not so familiar with all of the practices in the lending world to answer your question very well. I believe, you mean in the realm of commercial transactions and everything you see out there on any kind of recent agreements, arbitration is the device used to resolve disputes because it theoretically is doesn't take as long, isn't as expensive, and results in a quicker decision. This arbitration provision is a uniquely negotiated one, so you won't find one like this anywhere else. The alternative that the bank would have for your personal loan would be, state court, and this arbitration provision is an alternative to subjecting the tribe to a foreign court or subjecting the bank to the tribal court. So we have, in theory, this set of arbitrators who will be impartial and don't have anything, any axe to grind with either of the particular parties. I would expect arbitration is a pretty common provision in commercial loans, but I cannot tell you what percentage of those that it is. So.
Go ahead, continue.
I'd like to hear Mr. Harris's take on it as well, with your permission, Mr. Chairman.
Go ahead, Jay.
Thank you, Mr. Chair. Just would note something maybe what Bill was thinking but didn't note, that we could have got First Interstate Bank and Crow Tribal Court just as easily as they would have got us in the state court. It's all subject to negotiation in terms of what forum selection provision you would have in the agreement. We'd have the tribal court as a court of general jurisdiction. It would certainly have subject matter jurisdiction, and of course it would have party jurisdiction. The tribe waives its immunity in a limited fashion. That limited fashion could include limiting the forum that would be available to tribal court. So that was purely negotiable. Bill did note that the advantage to arbitration is you often get a much quicker decision. It'll be, in many instances, cheaper because of that, and you have probably a lot more flexibility in terms of what might be on the table, settlement, negotiation, things along those lines, than you might have in a traditional litigation context in court setting, but not necessarily. I know that with a creditor-debtor relationship, generally the states have, to some degree, in Montana is probably a good example here, protected the consumer against what are called unconscionable contract provisions that are in these boilerplate standard form contracts that are forum selection provisions, choice of law provisions, and in many instances are not enforceable. In many cases, that even precludes the ability to go into court. You're forced into arbitration, and what the big corporation or what the big company, the big creditor, is trying to do there is to avoid juries. That's one of the main things that they're trying to avoid, is getting before a jury and getting quote-unquote hometowned in a state court that might be sympathetic. A bunch of consumers on that jury, they might feel a little bit more sympathetic to a plaintiff that's going after General Motors or whomever. Anyway, I think what Bill noted as far as state court is concerned, this committee should know that tribal court was as viable an option as the state court was purely negotiable in this contract.
Okay, go ahead, continue.
Thank you, Mr. Chairman. In lieu of recess, I may have comments later. Thank you, Mr. Chairman, for allowing me to ask those questions and receive feedback from both respective legal counsels. I'll have comment later. Thank you very much, Mr. Chairman.
Okay, I guess for everybody's information, Carla is on her way over here. So we'll take a 5-minute recess.